When my grandfather passed away, he left me his 1,250-acre mountain ranch outside Big Sky, Montana. The property included a handcrafted log home, private forest roads, fishing streams, and several secure equipment buildings. Along with the deed, I inherited every original key to the estate. I spent my first week walking every trail, checking every fence, and inspecting each building. The ranch had been carefully maintained for decades, and everything was exactly as my grandfather had described. It felt like I was continuing a family legacy. One building stood apart from the others. It was a reinforced storage lodge that contained expensive ranch equipment, historical family records, and emergency supplies. Only 2 original keys had ever existed, and both were now in my possession. A neighboring HOA bordered one edge of my property. Although our lands touched, every survey clearly showed the lodge and access road were completely inside my ranch boundaries. I expected the relationship to remain friendly. A few days later, Karen Brooks arrived at my driveway with several HOA board members. She confidently informed me that the storage lodge had always served the community and demanded copies of every key. I politely declined and asked if she had any ownership documents. Karen insisted the previous owner had always cooperated with the neighborhood. I explained that I would gladly review any written agreement if one existed. Until then, I would continue following the recorded property documents. The following afternoon, I found fresh footprints leading toward the storage lodge. Someone had apparently tried the locked door without permission. The heavy steel lock remained untouched. To document everything properly, I installed several visible security cameras around the lodge and entrance road. Clear signs informed visitors that the property was under recorded surveillance. I wanted transparency, not confrontation. 2 mornings later, Karen returned with a police officer and claimed I was refusing to surrender community property. I welcomed the officer, invited him onto the porch, and offered every document he wanted to review. The deputy carefully examined my deed, county survey, and identification. After comparing the legal descriptions, he confirmed that the lodge appeared to be located entirely on private property. He encouraged everyone to resolve any disagreement through the proper legal process. Later that week, I visited the county recorder's office to verify every property document. I requested certified copies of the original deed, surveys, and historic boundary records. Every file matched perfectly. My attorney reviewed the paperwork and confirmed there were no recorded easements granting the HOA access to the storage lodge. Ownership had remained exclusively with my family's ranch for decades. The documentation was remarkably clear. To eliminate any remaining doubt, I hired a licensed surveying company to inspect the entire boundary again. Modern GPS equipment confirmed the same property lines recorded many years earlier. Independent verification strengthened the evidence. The survey crew placed new boundary markers around the storage lodge and photographed every measurement. Their final report clearly showed the building standing well inside my recorded property. There was no overlap with HOA land. When Karen received the updated survey, she rejected its conclusions and insisted the HOA deserved access anyway. My attorney quietly smiled and prepared for the next legal step. From that moment forward, every conversation would be supported by official records. A week later, Karen filed a formal complaint claiming I was denying the HOA access to what she called a shared community building. My attorney wasn't surprised. She immediately requested every document the HOA intended to rely on in court. During discovery, the HOA failed to produce any recorded agreement giving them ownership of the lodge or its keys. Most of their argument relied on verbal traditions and assumptions from previous years. My attorney remained focused on official records. The county recorder certified that the storage lodge had always been listed as part of my family's ranch. Tax records, insurance records, and property descriptions all identified the same ownership. Every agency reported identical information. To improve security, I upgraded the lodge entrance with a commercial-grade electronic access system. The new lock recorded every authorized entry while preserving the original steel security door. It was designed to protect valuable ranch equipment. The installation was completed in a single afternoon. Every access attempt would now be logged electronically, providing a complete record if questions ever arose again. Security had become both stronger and more transparent. The following morning, Karen arrived with several HOA board members demanding that I remove the new security system. I calmly explained that the lock protected my private building and complied with every applicable property right. The discussion remained civil. Karen called the sheriff's office once again, claiming I had unlawfully restricted community access. A deputy arrived and carefully reviewed the same certified documents already examined during the earlier visit. Facts remained unchanged. After reviewing the paperwork, the deputy explained that ownership disputes involving real estate were civil matters for courts. He thanked both sides for remaining cooperative and encouraged them to continue through the legal process. Everyone stayed respectful. The first court hearing centered on one simple question: who legally owned the storage lodge? My attorney presented the original deed, certified surveys, and county ownership history. Every exhibit supported the same conclusion. Karen argued that previous owners had allowed neighborhood volunteers to use the building during emergencies. My attorney replied that occasional permission did not transfer ownership or permanent access rights. The distinction became central to the case. An independent surveyor testified that the lodge stood entirely inside my recorded property line. His GPS measurements matched both historic surveys and county maps. The expert testimony carried significant weight. The judge reviewed every exhibit before announcing that the ownership evidence strongly favored the recorded property records. A final written decision would follow after additional legal review. Both sides respectfully accepted the schedule. While waiting for final ruling, I continued maintaining the ranch exactly as before.